Wendy and Jeff for being here today. And we're so excited to have them back to do this intellectual property workshop for you all. So let me tell you a little bit about who's talking to you. So Wendy is General Counsel at Knobbe Martens, and Knobbe Martens is one of the largest IP intellectual property law firms in the country. Knobbe has been the patent counsel to UH over the past 15 years, and so has a long history with UH as we engage in tech transfer and entrepreneurship and innovation. She has herself an amazing history. Prior to being at Knobbe, she served as general counsel for several billion-dollar manufacturing firms, and for the past 4 years, she was selected by Orange County Business Journal as one of Orange County's 500 most influential people. She also produces films with her husband Dale, most recently the award-winning film Hello, My Name is Frank. On top of that, she's a proud UH alumna. So she got her accounting degree from Scheidler and her law degree from the Richardson School of Law, where she was editor-in-chief of the Law Review. So we're also lucky and delighted to have her as a board member of PACE and a longtime loyal board member, and we're anxious for the pandemic to end so she can return her impeccable record of attendance in person at our twice yearly board meetings. And she's also been recently inducted to the Scheidler Hall of Honor. So Wendy, thank you so much. And that's a hard act to follow, Jeff, but we're so glad to also have Jeff Van Hoosear, who's a partner at the Orange County office of Knobbe Martens, Olson and Bear. And he focuses on international trademark and unfair competition matters. And of the many clients Jeff has served, some familiar names include Kate Spade, that's where my wife had her first job, Quicksilver, Toshiba, El Pollo Loco. He's the co-chair of the firm's trademark practice group, and he writes for the firm's fashion and beauty blog. And he received his BA in government from Beloit College and his law degree from Boston University. So Wendy and Jeff, thanks again. And I'm going to turn the program over to you now.
Fantastic. Thank you for the lovely introduction, Peter. And thank you to Crystal and Kirk and Tracy and everybody at UH Scheidler Pace who helped to coordinate this presentation today. Jeff and I are just delighted to have been invited to share some information with you today about IP law. Can I just see, I can't actually see you, but I'm assuming that none of you were able to join us a year ago, right before the pandemic started, when Jeff and I were very happy to come to UH and present a live presentation to you. That presentation was more of a general overview of IP law, and in particular, the 10 key things that you need to know about trademarks and rights of publicity and privacy. That is on Scheidler Pace's YouTube channel in case you want to catch this. What we thought we would do this year is to fine-tune that presentation a little bit, because what we discovered, we were delighted when we were talking with the audience members how actually advanced their knowledge was about branding and trademarks. So we're going to get a little bit more in depth this time and really focus on trademarks and branding. So with that, let's go to the presentation. Okay, there we go. Okay, so today in particular, what we did a year ago is what I call Trademarks and Branding 101, really a very elementary kind of presentation. Today, we're going to talk more about the tips, some tips and some traps for the unwary. We're going to talk story today, so it's going to be very informal. If at any time you have a question, please type it in the chat. But what we'd like to do is share with you some of the circumstances that have arisen with some of our clients and some of our new clients who come to us immediately with a problem. And I have so much respect for Jeff, my colleague, that almost invariably, whenever someone comes to me, I introduce them to Jeff, because Jeff, I've never seen him not be able to solve a problem when it comes to trademarks. So, so that's what we're going to talk about today. What I'd like to do is just sort of revisit with you some of the basics about trademark law. So if we can advance the slide. Okay. So before we get into trademark law and take a deep dive into trademarks, I wanted to just give you a basic overview, and for some of you it might be a reminder of what the 5 general types of trademarks are. If we can go back one slide. Oops.
Sorry.
That's okay.
I'm trying to get to full screen here.
No problem. So the first type of intellectual property is obviously trademarks. So what are trademarks? Well, trademarks can be words, they can be logos, they can be slogans, they can be something that we call service marks. So, you know, there used to be a company, I don't even know which company it was, that would say service with a smile, or way back when First Hawaiian used to say the bank that says yes. Okay, so all of those types of things are what we call trademarks. And what the trademark does, what its main function is its source identification. What do I mean by that? Well, when you see a trademark, you should be able to identify immediately. If the trademark's on a product, you'll be able to know exactly where it came from. Oh yes, I know where that came from. That is a Leonard's Malasada, because I see Leonard's on the package. Okay, you're identifying who made those yummy baked goods immediately when you see Leonard's Bakery on the package. Okay, so that helps you to identify who made the goods that you're looking at, who made the product that you're looking at. Or it could be a service. You know, Knobbe Martens is a trademark of our law firm. And if you see an email from Knobbe Martens, then you know that email is from us. So the source of the service provided is identified. What are copyrights? Copyrights are different. Copyrights involve an artistic expression. So what do I mean by that? So anytime you have an artist who is creating something, that is subject to copyright, to protection under the copyright laws. So what could that be? It could be a book. That's the most obvious thing you'll see on a book. It says at the bottom copyright, you know, 1999, or it could be a website page. It could be a song. It could be a film. It could be a script for a film. And, you know, why is that protected, or how is it protected? You know, typically you would file an application with the Copyright Office, and basically you're telling the world that I claim that to be my artistic expression, and I have a copyright in that. And what that does is it helps you to protect your work of art from those who may try to copy it or use it illegally. So you'll see that with songs as well. You know, if you, it used to be, I'm not sure if Facebook got a license, but if you play an entire song of an artist on your Facebook page, and like, let's say you went to a concert, they might put you in Facebook jail, because they'll say, well, you know, you had no authority to use and to re-show, to basically videotape and show this recording that you made at a concert. So songs and performances are subject to copyright. So that's the third type of thing. I'm sorry, that's the second. The third type of intellectual property is what we call a trade secret. So a trade secret is what it sounds like. It's something that you as a business, as an entrepreneur, considers to be confidential. Okay, it has to be confidential. So I was talking about trade secrets, and so that would be really something secret, the secret sauce. What is it about your business that you hold proprietary and confidential? What do you not want your competitor to know? So for example, a recipe for your product would be a trade secret. It would not be, even though I'm sure many of you who might have a business, maybe you have a baked good, or you know, one of our success stories is Pono Potions, right? They have these wonderful flavored syrups. Well, they have a recipe for that syrup, but they're not going to share that with the world, because then it's not a trade secret and somebody could copy them. That recipe is not an artistic expression. It's not subject to copyright. And so most chefs, most companies that make food or food products, they will keep those recipes as a trade secret. So for example, no matter how many people think that they have nailed the recipe for Leonard's malasadas, or, you know, a guava chiffon cake, you know, somehow it just doesn't taste right when you try those recipes. That's because those chefs who created those recipes are holding the recipe as a trade secret. Okay, so that's a third type of IP. The next type of IP you've probably heard a lot about, which is patents. What are patents? Patents are basically, it's an entitlement. It's a right that you can apply for and get from the U.S. Patent and Trademark Office. And there's also counterparts in other countries of the world. But what those patents do is you're seeking to protect innovation. So technology that you innovated, inventions that you created. If nobody else has claimed those inventions before, then you are entitled, you are granted by the U.S. Patent Office the right not to make that product, but to exclude others from making whatever it is that you claim you invented. Okay, so that could be the subject of, you know, a whole day of presentations. We're not going to get into that right now, but suffice it to say, there is this category of IP called patents. And one particular type of patent is a design patent. So unlike a regular patent, a design patent really goes after the design of a product. So for example, you know, my iPhone, I am certain that Apple has a design patent that claims this particular shape, and you know where the buttons are, and then on the back what the cameras and the viewers look like. And so it is possible and actually fairly inexpensive and fairly easy to get a design patent on a configuration that you've created, so long as nobody else has created it before you. Okay. So that's what a patent is. And then the fifth type of IP that we're not going to get into very much today is something called a right of publicity. And a right of publicity is something generally that a famous person would have. So for example, Bruno Mars has a right of publicity to his photographs, to what he looks like, to his name, Bruno Mars, and to his image. So if somebody tried to take a photograph and then, you know, make some sort of abstract art using it, and you could identify it as Bruno Mars, you might have an issue there, because basically you're capitalizing on his reputation, on him being famous, and you're using his image without his permission. So that's what a right of publicity is. So these are all things that could come up in the course of running your business or creating your business. But today what we're going to do is talk about, focus in on trademarks in particular. May I have the next slide, please? Okay, so we're going to talk today about every step in connection with a trademark. The first step being selecting your trademark, and then what we call clearing your trademark. So the first step is, gee, what should I name my business? So we're going to talk to you about how you choose a trademark and kind of some tips on doing that. The second thing we're going to talk about is clearing a trademark, making sure that the trademark that you chose is not being used by someone else. The third thing we're going to talk about is registering your trademark, which is a process that you would go through with the U.S. Patent and Trademark Office. There are also state trademark offices as well, which Jeff will get into. And then in order to keep that registration valid, assuming that the office says, yes, you're entitled to register your trademark, you have to do something called maintain your trademark, which means you have to pay a periodic fee and you have to show evidence to the government that you're still using the trademark with the types of products, the class of goods that you specified in your original application. We're going to talk about how you protect that trademark and the value that it has. There's something that we call goodwill that is associated with your trademark. And unless you protect that trademark, there's a chance that you could lose that trademark. So we're going to talk about that. And then we're going to talk about enforcing your trademark rights, meaning, you know, if your product really takes off, there's a really good chance that someone will try to knock you off, or someone may try to name their company selling virtually the same product and create confusion among customers. They may divert customers from going to your business to their business, and we want to prevent that. So there's a whole area that we practice, that Jeff practices, which is helping our clients to enforce their trademark rights. Okay, so one of the things I wanted to do before we get very far is to distinguish between what a trademark is and what a brand is. So a brand reflects the image and reputation of the company that's associated with the brand. So it's what the public thinks when they see a particular brand or a trademark or a logo. For example, on this page, when you see Toyota, what do you think of? You think of quality, reliability, you know, somewhat economic costs, so it's not too pricey. You think of availability. You know, Toyota's cars are all over the place, so that's what you think of. But with Porsche, or Porsche, I think is the correct pronunciation. With Porsche, you're thinking foreign car, you know, very stylized, German engineering, you know, sports cars, high speed, high cost, probably high maintenance as well for all of my friends who've had Porsches. So, you know, it's that sort of mystique, and that's what they're trying to build, is their brand, is the image of their product. A trademark, on the other hand, as I alluded to in the beginning, is one aspect of the brand that's unique and specific. It's something that can be protected, and as I mentioned, it identifies who makes the goods that are associated with that brand, with that trademark. Okay, so next slide, please. So here are some very popular Hawaii-based trademarks. We have Mauna Loa. You know, when you see that, you know, there's the branding there. You know that that's going to be a high quality, fresh roasted macadamia nut product. The University of Hawaii, of course, when you see that, you think of, you know, all of the brilliant people who teach at the university and who are students at the university and the wonderful programs. And so, you know, that you know exactly who they are and what they are by just looking at their logo and their name. Same with Zippy's, you know, one of my favorite places to go for a plate lunch when I'm in Hawaii. Town and Country Surf Designs, it's now TNC. Very distinctive. You know what kinds of products those marks are identified with, you know, generally surfwear products. First Hawaiian Bank, you know, that's a very recognizable trademark, and you know when you see that that's First Hawaiian Bank. Waihata is a wonderful sponsor and supporter of the university. Their products are actually services. they actually have products as well. But what they do, you've seen their trucks around town, is they are the major supplier of food to and also equipment to the major restaurants and hotels in Hawaii. So you identify when you see those trucks with that logo on it, you know that you're going to be getting, you know, high quality food products that have been sourced by Waihata. Diamond Bakery, those wonderful cream crackers, the wonderful graham crackers as well. Kamehameha Schools, you know, when you see that that's associated with the school for children of Hawaiian heritage. Big Island Candies, I discovered them this year. Also a major supporter of Scheidler. In my opinion, some of the best shortbread around, chocolate dip shortbread, and many, many other baked goods. Dole Plantation, who doesn't like a Dole Whip or a nice fresh slice of Hawaiian Dole pineapple? You identify when you see those goods and it's got the Dole emblem on it, you know where they came from. And likewise, L&L Barbecue, another very loyal supporter of Scheidler. So these are all Hawaii-based trademarks, and obviously there are others that are very famous as well. Next slide, please. So, you know, trademarks can be, they don't have to just be logos. They can be a combination of a logo and a word, or it can just be a word, or it can just be letters. So, you know, here we have the Louis Vuitton logo, which is just an L and a V. We have Amazon.com, Kate Spade, Peter's wife's favorite, or actually she worked there when at one time. Again, the University of Hawaii, Hawaiian Airlines, House Foods. That's another client of Jeff's, and I think many of you may recognize them as being the makers of that wonderful Vermont curry that I actually made last night, and I'm going to have tonight for dinner. And then IBM. It's just letters, but in this logo, it's a little bit stylized. So there's both sort of an artistic element and the lettering itself. Next slide, please. Okay, you know, and as I mentioned, it could be a word or a logo, or a word and a logo, and most of these are logos. Starbucks is the exception, but you know, when you see these logos, you know exactly what they are. I think the most famous, obviously, are the Starbucks and the Nikes, NBC, Apple, Microsoft, and Monster. Monster is a very large client of our firm, and they are very protective of their marks. They are constantly litigating against people who are using what they created, that M emblem, and basically causing confusion in the marketplace with customers. So very aggressive. They go after anybody who tries to use their mark. And the tree, the banyan tree at the bottom, I think that's a beautiful mark, and that also is associated with a supporter of Scheidler, which is First Insurance. Okay, next slide. Okay, so those were traditional marks. There are also non-traditional trademarks that probably you're not aware of, that don't come to mind. I don't know if you could hear that, but MGM, Metro Goldwyn Mayer, that's the original name for MGM Studios, but the lion roars, and that actually is a protected trademark. So there, you know, if you started a studio and wanted to have a lion as your mascot and have them roar, you wouldn't be able to do that because MGM would come after you and try to stop you. The other one is this cute little Pillsbury Doughboy. Pillsbury actually has a trademark on the cute little giggle that the doughboy makes when somebody tickles his tummy or pushes in his tummy. Okay. We have slogans, as I mentioned. Some famous ones are melts in your mouth, not in your hands. I'm sure you know this one. That's M&Ms, right? Just do it. Just do it would be Nike, right? Those are protectable trademarks because they're slogans. Or it could be, like I said, it could be a service mark. It could be a slogan associated with the service that you provide. And interestingly, another type of trademark is color. So believe it or not, Owens Corning has registered the trademark for the color pink, this certain type of pink that they use and they color their insulation with. And so if you try to create an insulation company and try to dye your insulation pink and try to sell that, you would get stopped by Owens Corning because they very vigorously protect their mark. And then finally, we have product configurations or shapes of products that if you look at this shape of this barbecue, you know that that's a Weber grill, okay? So that shape is actually protected under US trademark law from people copying that shape when they're making their grills. Next. Okay, so the first step in the process, as I mentioned, is selecting your trademark. So, you know, it's something that should be done very thoughtfully and hopefully creatively. You know, many people just take their last name or their first name. You know, if I were to come up with a great cookie, I might name it Wendy's Cookies or Peterson's Cookies. Wouldn't be necessarily a great trademark, but if I could think of something else like, you know, melt in your mouth, Melties, you know, maybe that's a better trademark. But this graph here on your screen kind of shows you the continuum of trademarks that are great and strong and not so great, or maybe they're so bad that they actually lose their status as a trademark. So on the one end of the spectrum, you have trademarks like Haagen-Dazs. Haagen-Dazs is actually a made-up name. So the best trademarks in the world are made-up names. And if you have a made-up name, it is very, very unlikely that someone else is actually using that mark. So that's super strong. I actually had a client when I was a corporate lawyer once upon a time. Their name was fluorocarbon. And if you know anything about chemistry, fluorocarbons are very bad for the environment. So they decided after years of being named fluorocarbon that they wanted to change their name. They went through, I think it was a 6-month process to try to identify a new name for the company. And they ended up basically shortening their name and they called it Furon, F-U-R-O-N. And they, after doing a ton of searching worldwide, because they had worldwide operations, they decided that there was no other company in their business making the same types of goods that they made, rubber products, that were called Furon. And so they got the go ahead, they renamed their company, they rebranded everything. It was very, very, very expensive. But thankfully they had good trademark counsel, because the Trademark Council worked with them hand in hand to make sure that the name Furon was something that was strong. It's a coined word. It's a coined name. There is no definition in the English dictionary for Furon. Okay, so that's what we would call fanciful or coin. The next best type of trademark, not as good as a coin trademark, is an arbitrary trademark. So that would be a word that is used for a product, but pretty much has nothing to do with that product, namely Amazon. You know, when Amazon first started doing business, they were a bookseller. And Amazon really has very little, if anything, to do with books. So that's a good trademark. It's an arbitrary trademark for the types of goods that they were selling. The next best type, not the greatest, is something that's suggested. So like I was saying, if I named my cookies Melties, the idea is they melt in your mouth. Maybe not such a good trademark because it suggests that the cookies melt in your mouth. And one example of that, but they've protected their trademark and registered it throughout the world, is Microsoft. It suggests that it's software. The worst type of trademark, well, second to the worst, is a trademark that is descriptive, that when you look at the name of the company, you know exactly what they do. And that would be, for example, American Airlines or even Hawaiian Airlines. Hawaiian Airlines, you know for sure that that's an airline and that they fly to Hawaii, right? Of course, now they fly elsewhere as well, but not necessarily a great trademark because it describes what the product is or what the services are. And in order to keep that trademark, you have to prove to the trademark offices that your mark is so famous and so well known that it has acquired distinctiveness, meaning that people know immediately, okay, I get it. It's not just describing an airline that goes to Hawaii. It's got a reputation and people associate it with a certain type of service. So those are descriptive trademarks. The worst possible type of name you could choose actually does not qualify to be a trademark, and that is something that's generic. So like if I wanted to register the word phone for this, I wouldn't be able to get it because it's generic. Phone is a word used to describe this thing that I have in front of me. So you can't get a mark on that. But what can happen is you can name your product and it could be used in commerce or by you even as a noun instead of as a brand. For example, escalator, believe it or not, was once a brand, but it was so used as an actual name for a product that it lost its distinctiveness and its right to be a trademark. So it's no longer a trademark. I found that fascinating. All right, so at this point, I'm going to hand it over to Jeff, and Jeff can get into a little bit more about selecting trademarks.
Great. Thank you, Wendy. So again, I'm kind of following the chat here a little bit along, and I've seen some great examples where someone mentioned the Coke bottle, the original wasted Coke bottle as a configuration, a registered trademark. And then, of course, Apple is a great example for the arbitrary Apple for computers, just like Amazon in connection with books or now, retail sales in that regard. So we're going to move a little bit here on selecting a trademark and the traps, and just kind of some things here to be in consideration of when you are selecting a mark. And like the chart that Wendy went through, if you can come up with a fanciful or a coined name, those are by far the best. Obviously, there's a little bit of a rub. Legal wants you to be in the arbitrary category, and then marketing wants you to be in the descriptive category. Marketing one tells you, we want to be able to tell the examiner, the customers exactly what they're getting right away. Sometimes the compromise is moving it a little over to a suggestive mark in that regard, and then that works well as well in connection with that. So let's talk about selecting a mark and the traps that you need to avoid. So the first is this merely descriptive. And so in a merely descriptive mark, that would be refused registration and refused initial protection. Because it gives an immediate understanding of what the product or services is, the courts and the trademark office will say, we're not going to give you exclusivity to it, which is what a trademark registration gives you, until you've proven that consumers recognize your business, your goods or services as the source. And under trademark law, that is usually a minimum of 5 years. 5 years of use to show that your merely descriptive mark has now achieved the level of use and understanding with consumers, hopefully, that it's now protectable. So that's a long time period to be without protection of a mark, without registration, or without enforcement of a mark. So you want to avoid anything that's merely descriptive. Now, unfortunately, there's not a really bright line between what's merely descriptive and what's suggestive. And so usually you'll want to talk to your counsel, talk to others, and kind of feel like, where does this fall? Hopefully it falls on the suggestive line of it, that it takes more than just an immediate view of the mark to know what it means. If it takes more than one mental step or takes some type of thought or process, then you're in suggestive. And so that's good. So try to always at least be suggestive or farther to the left as far as those go. The other thing to be aware of is surnames. So again, surnames are not protectable until you can establish that they have achieved this, what we call secondary meaning, or that people look at it and they no longer see McDonald's as a surname, they see McDonald's as a source of fast food, a fast food restaurant. So when that happens, then you have protection. But initially, surnames are very difficult to get protection of, and so they should be avoided, or at least acknowledged that there may be some issue with that. What the Trademark Office does is they say that if there's more than 100 names that would appear in a telephone directory, then it's primarily merely a surname, and you're going to be denied initial registration. That's a very low number when you consider how many people there are in the United States of in like a telephone directory, and they're using a national directory here. So if your mark is a surname, you're going to face some uphill battles. So just be aware of that in selecting it. Likewise, geographical marks, and these could be actual names or they could be informal names. So LA for Los Angeles is merely an informal name, but everyone knows what LA stands for in that context. And so Los Angeles or LA would be geographical that would be denied initial protection. Again, you may be able to eventually get some protection for that, like American Airlines did or Hawaiian Airlines did, but it's going to take some time. And during that time, you're going to have to be comfortable that you're either without a registration, without real protection or enforcement ability to do that. So when you're looking at a geographical name, you need to be concerned about that and pick it carefully. The other thing about geographical names is that if there is a geographical name that has some resonance with the consumer, such as, for instance, if I had Paris and I wanted to use Paris either in connection with clothing or perfume, I most likely would be denied a protection for that always, unless my goods originated there. Because if I called my perfume Paris, and consumers would think, oh, this somehow must be connected with Paris, because Paris has kind of a reputation of perfumeries kind of there, then it's deceptive or misdescriptive. So if a geographical term is deceptive or misdescriptive, it's also denied. So don't think you can kind of get around it and call something, you know, a geographical term if that geographical term has a reputation for those kind of products. Laudatory. So laudatory marks are very, very popular. Laudatory marks would be any term that's complimentary or superlative, thrifty, super, best, like in Best Buy, or thrifty car rentals. So those types of terms of laudatory are in the same category as all the ones above it. They're going to be denied initial protection at the Trademark Office and denied initial protection in the courts until you have shown that you've used it long enough and sufficiently enough that consumers now recognize thrifty when you're talking about car rental as being a specific source. Or when you talk about Best Buy for a certain type of retailer, they know that you know what they're talking about. It's not just a general term in connection with that. So those laudatory terms, while really great from a marketing point of view, are not great from a trademark selection point of view in connection with this. I'm going to stop here and make a comment too. Sometimes you can combine things, like you could combine a laudatory term with a geographical term, or a surname with a geographical term, and then you might get outside of that individual restriction in connection with that category. The next term, and I'm going to go into a little more detail about this, is ornamental. So when you're selecting a trademark, make sure that it's not just an ornamental term. And by that, I mean just kind of decoration. I'm going to stop there because I'm going to do a more in-depth example of that one a little bit later. And then deceptive trademarks are those that would be considered misleading. So a deceptive trademark will not be registered at the trademark office or will not get court protection in connection with that. My example of that is that I had a client, an apparel client, who developed this relationship with a social media, an influencer, and decided that her blog would be a great name for a line of clothing in connection with it. Unfortunately, that blog name was called Cupcakes and Cashmere. So cupcakes and cashmere were two of this woman's favorite things, and she blogged about them. Unfortunately, for a clothing trademark, cupcakes and cashmere is not good unless all your clothing is cashmere. And in this case, that was not practical or possible in connection with it. You can't have cashmere footwear, for the most part, or lots of other cashmere types of things. And so that was considered to be deceptive because consumers seeing cupcakes and cashmere in connection with apparel might think or could think that it was cashmere related, particularly if it was a sweater or a coat or a skirt or a dress or something. They might think that there was cashmere in it. And if there was not, then that's deceptive. So you have to be careful about your marks, that there's not a deceptive or any kind of misleading quality to them. And that crosses a lot of other industries. Yes.
Jeff, we had a good question from Ben Carroll in our audience. He says, what about non-laudatory or demeaning or rude names?
So that's interesting. That there's been some recent cases on disparaging marks. And the Supreme Court of the United States, in connection with a trademark case, ruled that disparaging terms are entitled to protection. The case involving that was called the Slants. So the Slants were a band. I don't know if I can really call them a boy band, but they were a band of male Asian American or Asian descent, and they called themselves the Slants. And slants would be a derogatory term in connection with that ethnic group. But they said, look, we've adopted it, we're using it. And the trademark office said, no, we find that term, derogatory, and so you're not going to be able to register it or protect it. But the Supreme Court overruled that and said there's no restriction about registering derogatory terms in connection with that. We have not, as you can imagine, seen a rush of people trying to register demeaning or derogatory terms. There's been some terms that may be in bad taste or maybe offensive language to some consumers, but to those entities who register those, they feel like maybe our demographic is okay with that word, which my grandmother would call a bad word, and you're not allowed to say, kind of thing. You cannot register obscene terms, but obscenity is in kind of the eye of the beholder or the talker as to what is or is not in that regard. And so there have been some terms that have been allowed to register as being not obscene, whereas some people might think that they've crossed that line. So, but you are allowed to register, like you could register worst or terrible or whatever in connection with that. And I think it would be kind of considered kind of hyperbola, it would kind of be funny, I suppose, in that context. So there's no prohibition against registering, a non-laudatory or a demeaning term. You can even register disparaging terms, and you can register terms up to the line of obscenity. The Supreme Court still has put a line there at obscenity. They will not allow that to be registered in connection with it.
Jeff,
it's a good question.
Jeff, just a little heads up. It's 7:21. It's 5:21 Hawaii time.
Okay.
I think we started a tad late, but hopefully we can be mindful of people's time. I suspect we'll go over 5 or 10 minutes if that's okay with everyone.
Okay. And then the final category I have here is called failure to function. And this failure to function is that if you have picked a common word or phrase, like right now, there are probably over 1,000 trademark applications where people have tried to register COVID or COVID type terms in connection with quarantine or other types of things. Those are not going to go anywhere. Number of people have tried to register Black Lives Matter in connection with a variety of goods and services. Those aren't going to go anywhere either because those fail to function as a trademark. No one knows really the source. They're not identifying the source. They might be clearly identifying a social justice issue or some other phenomenon, but they're not identifying a single source. So the failure to function for common words or phrases are when you try to say, hey, I'm going to take this phrase and do it for clothing or for travel mugs or some other sporting goods, what have you, the trademark office is going to kind of stop that. So that would be kind of a waste of money and connection. Now you might have it as a tagline or an additional slogan in connection with your mark, but that can't be the mark itself. So in looking back again at what some of the words that we looked at here earlier, you can kind of see how all this plays in. And the nice thing I wanted to point out on this chart, you'll see a lot of circle R's in connection with it, with Mauna Loa, University of Hawaii, L&L, Big Island. That means that they have registered the marks. The other ones that don't necessarily have it, in fact, Town and Country may have it on there. It's a little kind of hard to see, but those mean that they all went through the process in connection with that. But looking at these, you can see, okay, well, here's something that's descriptive. Here's something that might be geographical, but University of Hawaii is kind of limited. I mean, it's a university in Hawaii. That's going to be the appropriate name for them. So they're going to have to, they're going to add a logo, a design element to it and take the time. Zippies I loved because I think that is a great suggestive mark in there that kind of tells you kind of, you know, what it is, and it's a little more in that. Some of these others like L&L is arbitrary. I mean, with that, it's probably named after two surnames or the families or the personal names, whatever, but that's kind of a great mark there. Here's my trap on ornamental. So if Town and Country was trying to register its mark, its yin and yang mark there, and use this as an example to the trademark office, one of these would get rejected. So the one on the far left, the black t-shirt with the large design, the trademark office considers that to be ornamental. They do not consider that to be trademark usage. What they like to see is really on the right, which is the inside neck label, which is typically where people would look at and say, that's telling me the source of this product. So that's what they really want. They will take the middle example where it's what they call discrete, which would be the one that's on the all black version on the chest pocket. They will allow that to be showing as being trademark use, or if the placement is, what's the word that they use? A non-traditional. So you'll see the pink version there on that same garment. It's kind of on this sleeve, kind of on the outside sleeve of it, which again wouldn't be a place you would look at normally for ornamentation. Now this also transfers to other articles too. When you're doing mugs or plates, houseware, tabletop types of things, if the design appears on the front or the surface of it, it's most likely going to get rejected from a registration point of view. If it appears underneath on the bottom of the mug or the bottom of the plate, then that's a source identifier to the trademark office. So keep that in mind when you're coming up with your samples and your specimens and what you're going to do to the trademark office. You want examples on the right or at least in the middle. Because your example there on the left is not going to fly with the trademark office. And so you will have wasted that time and money in connection with that.
And what Jeff is referring to is that in order to get your trademark, you're going to have to show evidence of use using that trademark for the class of goods that you've registered or applied for. And then when I talked about maintenance of a trademark registration, you're going to have to prove that you're still using that trademark by submitting specimens to the trademark office, showing examples or samples of how you've used your trademark in connection with those classes of goods that you applied for and registered.
Yes, and they're very strict, and that holds up or hangs up a lot of people in getting through the trademark registration process because of that specimen. On this next slide, clearing, you'll have noticed perhaps that we put clearing in quotation marks, and that's because we want to make sure you understand the nature of that term. It's very difficult to actually clear a trademark because in the US you have common law rights. You don't have to go through the registration process to have trademark rights. The internet actually has made the searching and the clearing much easier because everyone is on the internet, either on e-commerce, Amazon or eBay or Etsy or Facebook or Instagram, or you name it, you can go on and you can find it. But clearing a trademark is the process where we want to try to make sure that we are first, or that we have priority in the use of the mark for our goods or services. I've got a link there to the website to the US Patent and Trademark Office. You can do searching on there for free. Very kind of user-friendly to see if anyone else has applied for or registered the mark that you're looking at. We also heartily recommend that you do some common law searching on the internet just through the search engines. Google, perfect example, to look through there and just put it in and see what comes up and see if anyone else is selling marks, is selling products under that mark or has a company under that name in connection with that. There's also formal search services like what our firm would offer as far as in-house screening, what we call full searches that go very, very in-depth. They cost a lot of money and take a lot of time. And then internationally, we've kind of focused a little bit on the US here, but internationally you look at too, because trademark rights are territorial, meaning you got to go country by country in connection with that. And then also very, very important in clearing a trademark is the corresponding domain name available, or is there a corresponding acceptable domain name available? Those of you who have registered domains may know that it's very difficult now to find domains, in that regard. But so that searching and that looking is definitely necessary to go there. Registering a mark. So Wendy mentioned earlier, there's two levels. There's a federal level and then there's a state level. Every state has a state trademark registration process. Probably 99% of our clients do it on the federal level because they want nationwide protection. And the federal registration has some significant advantages that are listed here. Going into court, you've got evidence of ownership and validity. It becomes incontestable after 5 years, which is great because after 5 years of your registration, no one can say, hey, but I was using it prior to you. Too late. I mean, once you've had the registration there for 5 years, they can't stop you or prevent you or interfere with your use in that regard. The other nice thing for consumer products is you can record that registration with customs, and the customs services will do their best to prevent infringing goods into the US that have that same mark in connection with it. So that, of course, is a great savior in the apparel and the consumer electronics and sporting goods, cosmetics, etc., that kind of category. You can file a federal application on intent to use. You make that statement in the application, but the mark must be commercially used before a registration will be obtained. And part of that in use is a specimen or a sample of your use that we talked about earlier in connection with the town and country thing there. On a state level, if you are a local business, purely local business, particularly probably a service business in Hawaii, this might be a great avenue for you to start protection with. It's inexpensive, it's quick. The downside is it must be on actual use. You can't file until you're actually using it in commerce, and it's geographically limited. It's only for the state of Hawaii. But for local services types of business, this is a great start and a great way to start protecting it. In maintaining it, we used the escalator example earlier. Escalator used to be a trademark along with trampoline and yo-yo and kerosene and some others that are listed in connection with it there, but they became generic. So there are a lot of companies right now that do a lot of work. You might have seen a couple years ago, Velcro. Velcro did a very humorous YouTube commercial featuring their lawyers that Velcro is not generic. The generic term for Velcro products is a hook and loop. So they drew the distinction between calling something Velcro that actually was branded Velcro versus just hook and loop, the generic term. So you have your trademark though, as long as you use it, as long as it does not become generic. So you need to look out for that. Protecting a trademark is very important. And you can do a lot of this on yourself. And so once you've selected a mark, you want to try to make sure that you protect it by keeping others from using it. So use the internet. Periodically look at search engines, look at the e-commerce sites, look at Amazon, eBay, Etsy, see what's going on there. eBay has a specific program. Amazon has a specific program, their brand registry program, that if you sell on those respective platforms, they will help you protect the mark and help you keep others off of there. There's also formal watching services that our firm uses and many companies use that alert you when an application is filed that might be the same or similar to your mark, or when it's published, which is another stage in the registration process there. Enforcing a trademark, that duty is on the trademark owner. So a trademark owner has a duty to police against unauthorized use. If it does not, it may lose its trademark rights. That's one way a mark can also become generic, is if the trademark owner fails to police the mark, because it is failing in the consumer protection perspective of the mark. Because a mark also, in addition to being a property right to the brand owner, is supposed to help consumers know that when they see a mark, they're getting a certain quality or certain type of goods and services. And if that trademark owner fails to police and allows others to use it, they could lose those marks. So that's typically in what we call cease and desist letters that are sent. There's some things at the trademark office before the Trademark Trial and Appeal Board where you can oppose or seek to cancel another mark that may have gotten through that's too similar to yours. And then there's court actions that would provide equitable relief, which would be in the form of an injunction preventing someone from using a mark, or giving you back monetary damages in connection with that. And then perhaps in some cases, attorney's fees as well. So that kind of brings us to the end. We are happy to take any other questions that you may have.
Yeah, so we would actually love to open the floor to questions from the audience. You may unmute yourself and ask questions directly to either Wendy or Jeff. So take it away.
And before you speak, when you speak, we would love to hear kind of your story, what brought you here today, or what kind of business you're starting or have started. That would be really interesting for me and Jeff. Don't be shy. We called this Talk Story for a reason.
Hi, my name is Kobe, and I'm part of a team called Pair. And it's funny, we saw this article because our name is Pear, and we saw that Apple went after Pear, even though they don't have, I mean, it's very different fruit, but just because they stole the concept of having a fruit as their logo. And so we don't have a Pear logo or in our logo, but obviously our goal is to get big enough where they actually sue us, but we're actually surprised they said that they went after this small business. So anyway, I just want to see if you guys have any thoughts of, should we just give up because it's so close to Apple that we should just change our name, or do we have hope?
What are you selling?
It's a healthcare company. So we actually pair young adults with older adults, a service-based company.
But it's PEAR.
Correct.
Nice.
And Pair has, I mean, we have no money and they have a lot. So we're just.
You know, a few years ago, I would have said you were probably okay because Apple wasn't probably in healthcare at all, but I don't know if that's still true to this day, currently. Some of those companies are pretty much in everything. And of course, how we offer services and what services offer has completely changed within the last 5 years. The thing going for your mark is the kind of what I'm going to call the double entendre, which is pair, P-A-I-R, where you pair, you know, people up together in a sense. And if you can play off that kind of connotation of it, then that would be very helpful to you in steering away. You are correct. Apple has gone after others. I know Pineapple. I know that they have prevented Pineapple from, you know, using in connection with computer or consumer electronics. But you know, Apple is in the music business, entertainment business. They offer a lot of other variety of services. I'm not specifically aware that they're in healthcare, but it wouldn't surprise me if they have something, you know, in connection with that. But if you emphasize the pair and pairing, P-A-I-R, that's your best avenue, kind of thing, you know, in my opinion, right now to work and work around them. Also, don't use their font style, don't use their colors, don't trade off any other kind of acknowledgement or what we would call goodwill. Wendy referenced that at the beginning. That's important too in connection with steering away from an infringement problem.
Awesome. Really appreciate the feedback. Oh, go for it, Wendy.
Kobe, is your mom Sandy?
Yeah, she is.
I'm looking at you and I go, you look so familiar. I've seen you on her Facebook posts.
Oh boy.
And I thought, oh, so anyway, I'm old enough to be your mother.
Oh.
I went to IAEA High School with her.
Oh yeah. Oh, fun. Well, I'll let her know you said hi.
Tell her I said hi.
Yeah. Thanks for the feedback.
Thank you, Kobe. So we have a question from Duran. His question is, so as we participate in this year's UH Venture Competition, how do we secure our company idea, which is currently in the idea stage, and what is the best way to secure our idea/company?
Darren, I don't see him on here, but is your idea in innovation, or is it a concept like we are going to start a, you know, mobile pet beauty salon? You know, I don't know what you mean by your idea.
Oh, hi. Can you guys hear me?
Oh, there you are. Okay. Yes.
Oh, hi. So yeah, I'm looking to start like a solar company, but we're focusing on like transparent solar. So it's currently just like an idea, and I think the technology is out there right now. But like as I try to ask people for information and we talk about it, trying to get more like market research, I kind of am scared about sharing too much, just because like the whole thing about people sharing your idea and stuff. So.
Of course. Yeah. So, you know, what I think what you're talking about is whether or not your idea of perhaps combining things together to create energy, whether that is patentable. And for that, you might do some reading on the internet about what can be patented and what cannot be. And, you know, once you kind of ascertain that you're the first one to come up with this idea, now you also have to make sure that you figured out how to make it work. Then, you know, perhaps you can talk with a patent lawyer if you don't know one. You know, maybe I can twist an arm here at my firm and get someone to talk with you, you know, very generally without disclosing your inventive feature or your secret sauce, about whether they think something might be subject to a patent. You can actually do some searching on the US Patent and Trademark Office database to see whether someone has already invented what you're thinking about.
Darren, the other thing you'll want to do is that if you've got a company name or a service mark or trademark, you would file those first. So because once you get those on file, you've kind of reserved your spot or your places for those. So if you develop a very distinct logo you could trademark it, you file it at the trademark office, file it perhaps at the copyright office as well in consection. Some of the marks we saw on the trademark page clearly could be copyrightable as well. They have the required artistic expression. If you have any other, if you have some other marketing materials or other things, you can do that through the copyright office. But the other thing you would look at doing is having a confidentiality agreement or an NDA, a non-disclosure agreement, with anyone that you're having participation with. As far as that, you would have a contractual relationship with them that they would keep it confidential, not use it for other purposes, other than if you develop, continually go with them. And so a lot of times an NDA or non-disclosure agreement or confidentiality agreement are used with potential investors, potential employees, in connection with it. And that's a contractual relationship outside of the IP. But for the IP, you either need to have a trademark on file, a copyright on file, a patent application on file to kind of set that place in line for you on that.
Yeah, so Darren, right now what you're thinking is all trade secret information. It's proprietary confidential information. Tracy and Crystal, since you've been with PACE for a while, do we have a database of documents like an NDA form that our entrepreneurs could use? Do you know if you have such a thing? If not, maybe we can help you create one.
Yeah.
We actually don't. We have other resources, but not like legal documents.
Oh, okay. Okay. We'll figure it out because Jeff and I are not licensed to practice law in Hawaii. So we have to make sure that we do this legally and maybe have, we can prepare it and you can have a Hawaii lawyer take a quick look at it or something. Okay.
That'd be awesome.
Do we have more questions?
I wondered, are you familiar with Nolo Press? They have a lot of real plain language stuff.
Yeah. Oh, that's a great idea, Ben. Yeah, you could probably find an NDA on the internet, a free legal form. I would venture to guess maybe Nolo has that type of form even available for free. There's something to be said for having someone thoughtfully prepare one, or we always like to think that our firm might have a better form, but not necessarily so, for something as simple as an NDA.
Well, I would use it just so that you can talk to somebody professional in an informed way, kind of do some legwork ahead of time.
Yeah, using the NOLO form is far better than using nothing.
Right. And there are certain professions like lawyers. If you're talking to a lawyer about potentially engaging that lawyer, in every state of the nation, there is a duty of confidentiality to that prospective client, even though you may not have paid that lawyer a single dime. So you're already protected. I'm not actually sure about accountants. Certainly it's not true with engineers. Engineers have no duty of confidentiality, or designers. Anybody else with a question?
I'll jump in. I was interested in the discussion of pairs. And it sounds like the critical factor is there a similarity of business? And I'm wondering if Apple wanted to go into it and do work but wasn't actually in it, would they still have something to go on if you were in it first, but they wanted to be in it? I mean, they got the money, so that talks too, but.
So it's a balance. I think of it as a scale. So if you've got the marks on one side and the goods and services on the other, it's a scale, it's a balance. So the closer the marks are to one another, like identical, the goods and services don't have to be as close, and then the vice versa. And so if you were looking at pair for in a personal electronic device, some type of computer, laptop, what have you, then that's not good, because you've got similar meaning marks, similar kind of context or connotation of the marks, and you've got the same goods or services. But healthcare is different, because healthcare is not something, again, I'm not aware that Apple is doing any healthcare, but they could be something in there. As far as your question, trademark law has this concept that's a little fuzzy called zone of natural expansion. So the zone of natural expansion gives the trademark owner some protection outside of what they're doing. So if I have a client that does apparel, but they don't do footwear or they don't do sunglasses, they probably have a right to go into footwear or go into sunglasses, because those goods are related to apparel from a consumer point of view and a market point of view, where someone seeing the same mark on apparel as footwear or the same mark on apparel and then sunglasses would think there should be an affiliation or connection because those are related. But if I was in apparel and I had a mark and someone wanted to do cat food is probably outside the zone of expansion for apparel. We talk about lifestyle brands a lot, and there's a lot of lifestyle brands out there, major brands that do a lot of things. They do, in addition to apparel, they do cosmetics, they do fragrance, they do sporting goods, they do luggage, they do linens, household linens, tabletop, things like that. Those lifestyle brands have a very good zone of expansion, but they only get to be called a lifestyle brand when they actually have done a lot of those things in connection with it.
Interesting.
Thank you, Ben. Does anybody else have any questions for Jeff or Wendy? Last chance, last chance.
Well, feel free if you have a burning question this evening and you can't sleep, zip us an email. Our website is knobbe.com. The way to remember it, it's like Obi-Wan Kenobi, spelled KNOBBE.com. And you can find Jeff and me there. Happy to answer general questions about the topics we discussed today, or even if it's not exactly what we discussed, maybe we can point you in the right direction. But we love the University of Hawaii. We love the students who are studying there, and we want to support you. We want to keep connected to Hawaii. It pains me that I live on the mainland and I've lived here for 36 years almost. And that's why I love to come back at any opportunity. So hopefully, when this pandemic subsides and everybody's vaccinated and healthy, we will return if you'll have us, and hopefully we can get together, and by then we will be just blown away by all of the wonderful businesses that you've created. Go for it.